Here now, Andy McCarthy, former assistant U.S. attorney for the Southern District of New York, a Fox contributor. Andy, you've been following this trial incredibly closely. What did you make of this issue? I thought it was filed, this application for a mistrial by the defense, because of this low-res versus high-res video was filed with prejudice, meaning that they want to prevent the prosecution from bringing charges in the future. But what do you make of that motion, and also where, with the questions the jury sent, where the deliberations seem to be?
Yeah, it's a significant motion, Dagan, and it's not a standalone. The other thing they emphasize, if you remember about a week ago, we had an issue where the prosecutor commented on the defendant's Fifth Amendment right to silence, which is kind of a third rail in trials that prosecutors are supposed to know you're not supposed to go near.
Right. And
he decided to go there. So, it's a combination of things, but I think it's a significant issue. And I think the judge was wrong to let the drone video come into the case in the first place. What it essentially allowed the prosecutors to do is take this disputed video and essentially testify to what they thought was going on it, with no testimony from anybody who was actually on the scene. So it was a really, it was an important, as it turned out, an important piece of evidence in the trial. And if Rittenhouse is convicted, I don't think he will be, but if he is, it'll be a significant question.
But correct me if I'm wrong, this most recent motion was filed with, it was a motion for a mistrial with prejudice, wasn't it?
Yeah, well, there's kind of a sliding scale of what they want, Dagan.
Okay.
So right now, if the judge were to rule on the motion, they need it to be with prejudice, because they have a jury in there deliberating that they think they have a good chance to get an acquittal from. So the last thing they want to do is have a mistrial, lose that jury, and then they get retried again, right? So what they would want in the first instance is, judge, if you're going to throw it out with prejudice, so he can't try him again. In the alternative, I think what they want is, let's see what the jury does, and then this is a motion after a post-trial motion. If the jury convicts Rittenhouse, the judge can look at this and first decide whether to throw out the conviction, and then decide whether there was such prosecutorial misconduct that it warrants them not being able to retry him. Usually, if there's a hung jury, or if a judge throws out a case on grounds other than the sufficiency of the evidence, the government can try him again.
Right.
But if you throw out a case on the basis of prosecutorial misconduct, they can toss the whole thing.
As a former prosecutor, do you see misconduct from where you sit?
I agreed with the judge that they have to take some testimony. Let me just talk about two categories of misconduct, right? So when you're dealing with trials, especially toward the end of the trial, where everybody's been working 18+ hour days, mistakes happen. And as a prosecutor, whether you are acting in good faith or sinister, you still owe the defendant due process. So if you've deprived him of due process, then that's a problem, whether you did it by accident or on purpose. Whether it's by accident or on purpose may weigh on whether you get to try him again. But if you've denied the defendant due process, the conviction would have to go. So that's, they'll have to get more evidence about exactly what it was that the prosecutor turned over here. And did somebody make an honest mistake, even though it was a very costly one? Or was this something that was really a sinister scheme?
Before we go, where do you think the jury is in deliberations? Some messages sent, they rewatched a key piece of video today. And also, based on what their questions were, can you make out where they are in terms of, assuming they might be going in order on the charges, where they are in the order of the, 5 charges against Kyle Rittenhouse?
Yeah. As they say, Dagan, this is always reading tea leaves, because you never know if they're actually working systematically through the indictment, or if they have like a 10-2 or 11-1 deadlock and they're trying to hammer the minority jurors with evidence. So we won't know the whole dynamic until after the trial's over and there's some reporting on it. But it looks to me like what they've homed in on is the only real factual issue in the case. The government, the state, says that Rittenhouse was the aggressor in the all-important first confrontation with Rosenbaum.
Right.
And they claim that that's his provocation and that causes his right to self-defense to be extinguished for everything that follows. Rittenhouse's position, and I think this is the stronger one, is that he was the one who was pursued. The other, Rosenbaum was the assailant, not Rittenhouse. That seems to be the main thing that they wanted to look at the video evidence for. And they also wanted to look at it in connection with Grosskreutz, who was the last person who shot. So if they're actually working systematically through the indictment, you could infer that they're at the end, but who really knows?
Indeed, Andy McCarthy. Thank you so much for being here always, Andy. Such a pleasure.
Thanks, Dagan.